Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Good morning, everyone. I'm so sorry, but Professor Lucas can't be with you today, and he asked me to be your hoster, Professor Michael. Professor Michael Wood, it was already well presented for you, everyone. He is a member of the International Law Commission and a senior fellow of the Lauterpacht Center for the International Law University of Cambridge. Professor Michael, it is a very pleasure. Sir Michael, Sir Wood, it was a very pleasure for us to hear you the last day. And today I hope to continue talking about the identification of the customary international law. Take your time. You can begin as soon as you want. Thank you very much for your presence here today, again.
Well, thank you very much, Professor. I should say I'm not a professor. I'm a practitioner, not a professor.
Oh, yes, I'm so sorry, yes.
Anyway, firstly, to thank the organizers again, and to thank Professor Brandt in particular, who we just saw, and Paula for all the organization. I plan, as last time, to speak for about 50 minutes, not more, and then leave plenty of time for for questions. I think answering questions is much more interesting than just speaking.
Okay.
In the first lecture, I talked about the International Law Commission in general, and it's gave a brief overview of the work it has done in the field of the sources of international law. And now in this lecture, I want to focus on customary international law. There are really two aspects to this. The first is how the International Law Commission itself approaches questions of customary international law in the course of its day-to-day work. That's quite a difficult subject, but fortunately the UN Secretariat, the Codification Division, prepared an excellent paper back in 2013, which I would commend to everyone. It's a memorandum on elements of the previous work of the International Law Commission that might be relevant to the topic identification of customary international law. And the members of the Secretariat went through, I think, all the work of the International Law Commission and tried to distill the way it had approached the identification of customary international law. And they came up with no less than 31 observations, which make a lot of sense, and they're actually not so different from the work that the International Law Commission then did when it came to its conclusions. But I won't say any more about how the International Law Commission itself looks at customary international law, other than to commend that memorandum to all of you. The second aspect, of course, is the work of the International Law Commission on the topic identification of customary international law. I'm sure everybody knows that customary international law is often regarded as a great mystery for students and for teachers, though I have to say that in practice, it's not usually so difficult. I think it's made mysterious by quite a lot of the academic writing on the subject. Strange theories are put forward that try to take apart the accepted view of customary international law. It's also, I think, difficult, partly because of this, for national judges and for lawyers who are not experts in international law to approach questions of customary international law. And it was particularly with this in mind that the International Law Commission took up the subject. It was felt, and some of the judges in England, for example, told me they would find it very useful if there was a more or less authoritative guide to how to find rules of customary international law. They said the same about Jus Cogens. They said even more they would like to have a guide to Jus Cogens. But so it was this approach to try and come up with some guidance, not too dogmatic, some flexible guidance, that the International Law Commission approached the topic. And I was appointed the Special Rapporteur in 2012 for the topic, and some 5 or 6 years later, we completed the work in 2018. I'd like to emphasize, though, that it's very much a collective work by the Commission. The Special Rapporteur has an important role. He or she puts forward reports with their own views, their own proposals, but these are almost always radically changed by the debate and the discussion in the Commission itself, and the outcome is not necessarily what the rapporteur proposed. It's almost always, in my view, better. I'm a great believer in the collective approach to these matters. So the outcome from the Commission's work on the topic was really threefold. I call it a triptych, like a painting. Firstly, there are 16 conclusions with commentaries. And these can be found in the yearbook in the report of the Commission for 2018. Secondly, there's a bibliography, a very extended bibliography that can also be found in on the website of the International Law Commission. It was updated in 2018, and it's some 30 or 40 pages long. And I must say, I find it very helpful. It was largely prepared by my assistants, and it's really an excellent guide to the literature on the subject. And then the third part of the output was prepared by the Secretariat, and it's a document entitled something like Ways and Means of Making the Evidence of Customary International Law Available. And that is a document of some over 100 pages. The Secretariat contacted every state and a lot of academic institutions to try and get websites, to get details of where to look for the practice and opinio juris of states, and the practice in particular fields like the ICRC work. And that's a very useful document, a very practical document. Now, the 16 conclusions with commentaries, the first thing to say about them is they have to be read together, the conclusions and the commentaries. The conclusions are usually very brief. The commentaries explain in some detail what the conclusions are referring to, but all together they come to about 35 pages. So it's a very readable output. I compare it always with Professor Pelle's Reservations to Treaties document, which is 650 pages with maybe some 200 guidelines. Here we manage 16 conclusions with commentaries, and they're deliberately kept short, but I think they've got a lot of information in them. Another feature of the commentaries, which is quite interesting, I think, is that they don't contain a single reference to any writings. There's no reference to any academic literature. As I've said, we produced a very full bibliography with the academic literature, but we don't cite it as authority in the conclusions and the commentary. And this was very deliberate. We had quite a long debate about it, with some members of the Commission saying we should, and it's not respectable not to, and others saying that we shouldn't. And very interestingly, they had exactly the same debate when they dealt with the law of treaties under Professor Waldock. And in the end, the final draft articles on the law of treaties from 1966, again, don't contain a single reference to any literature. They refer to practice, to state practice and the like, but not to the literature. And that was deliberate, following a long debate. I think one of the reasons for this is that it's very difficult to be selective. One could, of course, put your favorite book or your favorite article, but to try and be fair, to try and cover the whole world, articles, literature in all the various languages, it's really very difficult. But also, I think it's accurate because it shows the subsidiary nature of literature. So that's the outcome, 3 parts: conclusions with commentaries, bibliography, a document on ways and means. The next really important thing is to look at how this was received by states. As I've said, we finished the work in 2018, and there was a debate in the UN General Assembly also in 2018, 2 or 3 months later, in the 6th Committee. And it's important, in my view, to assess the value of a document, to look at the debate in the 6th Committee and what the 6th Committee did with it. On the whole, if you read the debate, I think there's a lot of compliments states saying that they considered that the conclusions offered important practical guidance on the subject. There was support, very much support, no objection at all to the conclusion, the first central conclusion, following the two-element approach to customary international law. You have to find state practice, you have to find opinio juris. No questioning of that, unlike in some of the academic literature. There was support for the view that it should be a rigorous and a systematic matter, the search for rules of customary international law, but equally, it was pointed out there has to be some flexibility. And I think the balance between the rigorous nature of the exercise and the flexibility was generally welcomed. There are a lot of elements of flexibility which I could list very quickly. For example, it said that assessing practice, you have to take into account the particular circumstances and the context of the alleged rule. You see this in the jurisdictional immunities of the state case in the ICJ, where they say in this context of the immunity of states, you have to look very much at national court decisions. That is practice of particular value in this field. So there's flexibility there. We also say you have to look at the overall context, the nature of the rule in assessing practice and opinio juris. I should say the fundamental approach we took is that it is the same exercise in all fields of international law. You can't say, well, in the field of human rights, you really don't have to worry too much about practice because all states violate human rights. You just look at opinio juris, what states have said. In the field of international humanitarian law, practice is very difficult to find because it's the battlefield, etc. But the Commission took the position that it is essentially the same exercise in all fields of international law, and that is important to maintain the unity of international law. You can't break it up into separate branches and apply completely different methods to finding the rules in each field. It has to be done by a single method, but at the same time you have to take account of the realities and the context, for example, the importance of national decisions in the case of immunity. Then we took the view that practice itself takes a very wide range of forms, and we emphasize that it includes verbal practice as well as what might be called practice on the ground or practice on the battlefield. What states say is also practice. For example, in a protest note, that can be practice. And that it also includes inaction under certain circumstances, but you have to be very careful about that. We took the view that the same material can be used to find both practice and opinio juris. For example, a diplomatic note protesting about something is practice because the state is protesting about an incident. That's the state's practice, but it also may have opinio juris within it because it will have the state, or it may have the state, saying what its view is of the rules of international law. So the same document, the same event, can be both practice and opinio juris, but it's a separate exercise to look for practice and opinio juris in each case, even if you're looking at the same document. I could go on with the flexibility that I think we built into the conclusions, but I don't think I need to. I would say that one or two writers have commented that it's very inflexible, it's too rigid. There was a blog on opinio juris in the last week or so by Monica Hakimi, saying this is completely wrong. They've tried to lay down rules, which actually we didn't. We set out conclusions that are not rules. And they're following a rule book approach. They should be looking at everything and taking it very flexibly. And I think her criticism is not justified. The argument that it shouldn't be too difficult to find a rule of customary international law, of course, there's something in that. But on the other hand, it shouldn't be too easy either. If a court finds a rule of customary international law, a rule that people didn't realize was there before, then they're finding a rule of law that is binding on all states. That's quite a serious thing to be doing. It shouldn't be too easy to find rules of customary international law because they have very important consequences. And if one finds rules of customary international law too easily, it may lead to a devaluation, if you like, of customary international law, with states not taking the system of customary international law seriously. And one of the aims of the Commission is to ensure that the respectability of customary international law, to avoid states saying, well, it's all over the shop, nobody knows what they're talking about. We have tried to show that we do indeed, and those who seek rules of customary international law, seek to identify it, do know what they're talking about and should be following these basic rules. Now, can you hear all right? I saw you putting earphones in. It's all right, is it, the sound? Good. So I think the debate in the Sixth Committee is important. There were a number of comments made, one or two criticisms, which are important and should be taken into account, but not, in my view, fundamental ones. One of the most controversial parts of the conclusions is where it says that the practice and opinio juris of international organizations as such, as opposed to their member states, may be relevant when determining rules of customary international law. That proved to be the most controversial provision in the conclusions, with one or two or three, not many, members of the Commission being rather opposed to that, saying, where is the evidence for this? What does it mean when you have 2,000 international organizations? Can they outvote states? How does this work? And one or two states in the Sixth Committee expressed caution about this. In fact, I think if you look at the conclusions and you look at the commentary, the Commission also have been cautious. They've said it's really only where states have transferred competencies to an organization, as for example, the members of the European Union have done to the European Union in quite wide areas of international relations. It's particularly then, perhaps where there's also joint competence, that practice of organizations may be relevant, but also in fields where organizations enter into treaties, for example, that must form part of the practice relevant to the customary international law applicable to treaties involving states. Likewise with the responsibility of international organizations, though I have to say it's often very hard to find the practice of international organizations. On the whole, they're worse than states when it comes to publishing what they do and what they think. So we have also, the Commission has also been cautious, but that was one of the criticisms. There was also caution expressed about the use of inaction as practice. Very understandable caution, but inaction is undoubtedly an important part of the practice that builds up rules of customary international law, but it has to be deliberate inaction. It's not just a state doing nothing. It has to deliberately abstain, for example, from prosecuting an official who's entitled to immunity, or from a use of force, or from a certain use of force. Deliberate abstentions can be very relevant to the formation or the identification of customary international law. In the debate in the Sixth Committee, a lot of attention was paid to the conclusion number 15, which is about the persistent objector rule. This was also one of the controversial provisions within the Commission, with one or two members, including, I seem to recall, a member from Brazil, expressing doubt about whether this was a rule of international law, despite all the evidence that there is for it, and indeed some case law of the International Court of Justice. But it was an aspect that got a lot of attention from states in the Sixth Committee. I have to say, virtually all of them very positive, saying we're glad that you have included the persistent objector rule. Of course, states rather like it. It keeps their freedom of action occasionally, but very occasionally. But just one or two states who have traditionally been cautious about the persistent objector rule, for example, Cyprus and Greece, because Turkey regards itself as a persistent objector to certain law of the sea matters. But very few states express serious doubts about that rule. But it is important in determining the value of something like these conclusions, to see what states said about it in the Sixth Committee. And then what did they do about it? Well, the General Assembly adopted a resolution 73-203, on the 20th of December 2018, and they did a number of interesting things in the resolution. Firstly, they took note of the statements in the Sixth Committee. So they emphasized themselves the importance of the statements in the Sixth Committee. They then took note of the conclusions and the commentaries, and they annexed the conclusions to the resolution. They, in doing so, deleted the word draft, because the Commission always calls its output draft conclusions, but the General Assembly sometimes deletes those words, the word draft, as it did with the articles on state responsibility, for example. So it took note of them, it annexed them to the resolution, and it said that it brought them to the attention of states and all those who may be called upon to identify rules of customary international law, and it encouraged the widest possible dissemination of the conclusions. So I think it's, on the whole, a very positive outcome. I would call it an endorsement, at least in general terms, of the conclusions, though a reference to the statements in the Sixth Committee is very important. Another thing they did in the resolution, interested by the ways and means, the practical problem, how do you identify state practice and opinio juris? They once again encourage states to publish digests and surveys of practice in the field of international law to support existing publications. I think there are probably some 30 or 40 or 50 existing publications where states publish their practice, but a lot of states don't. And so encouraging states, perhaps collectively. I know the African Union was thinking of publishing some African practice in the field, which would be very welcome. The Nordic states have published practice, or the Baltic states. So that's an important thing which the General Assembly have encouraged states to do. It will be interesting to see how many states pick that up. Can you hear all right still? I saw sort of hand signals. Good. Of course, it's too early to make any assessment of the value of these conclusions. I'm pleased to see that they have been referred to in a number of recent publications, in new editions of manuals and the like. It seems to take a long time, though, for things to get into published form. That's partly because publishers spend so long publishing books. So things that were written in 2018 are only just being published now. That always rather surprises me. The president of the International Court was very complimentary when he addressed the Commission in 2019. President Yusuf said that we'd, done a good job. I have to look at his exact words. He was pleased that we had completed work on the conclusions. The conclusions themselves are being used by the International Law Commission in other topics. They've been referred to quite a bit under the topic immunity of state officials from foreign criminal jurisdiction. The special rapporteur there has referred to the conclusions quite a lot. They're referred to in the first report on sea level rise. That's a new topic. They've been adopted almost word for word in the draft conclusions on jus cogens in certain aspects of those. So they've been influential within the Commission. They've also been quite influential in court cases, at least in England. We had two cases in the English courts, or two judgments recently, one of which said they had followed or tried to follow the methodology set out in the conclusions, and they annexed the conclusions to the judgment, which I thought was very kind of the Court of Appeal in England. That was a case called the Freedom and Justice Party case, involving the question whether a person on a special mission enjoyed immunity under customary international law. And the court spent about 90 paragraphs examining that question and following the methodology recommended by the International Law Commission, and concluded that there was a rule of customary international law under which persons on special missions enjoyed at least immunity from arrest and detention and from criminal prosecution during the period of their time while on the special mission. It's a very interesting judgment, and I would commend it. The Dutch courts earlier this year also had to decide a question of immunity. This was in relation to the immunity of former military officials for official acts that might have been war crimes. And they examined the work of the International Law Commission on that subject, but they also referred to the work on the determination of, on the identification of customary international law. So there have been a number of cases already which have used these conclusions, which is quite helpful, or quite, sorry, not helpful, it's quite gratifying to the Commission and to me in particular. I should say that the Commission were very conscious that they weren't laying down rules. These aren't, I think, rules of customary international law about how to identify rules of customary international law. They're more rules of recognition, if you like. They're not, their normative value is a subject of some debate. And this blog recently by Professor Hakimi that I mentioned, she criticizes us for laying down rules. Well, we deliberately didn't lay down rules, and we said we weren't laying down rules. We're offering flexible guidance. That's why they're called conclusions. They're not articles, they're not purporting to lay down rules. The Commission's often rather careful what it calls its output, and conclusions is a very neutral term. These are our conclusions about the methodology for the identification of customary international law. Another thing is we were very careful to say that we were only setting out the methodology as it is at present. We weren't saying it should always be this for all time. There's obviously scope for change in the methodology, though I wouldn't encourage it. But we very much tried to describe the current state of international law, the current methodology applied by international courts and tribunals and by states when trying to identify rules of customary international law. Those, for example, who criticized us for saying the practice of international organizations might count, say, that's lex ferenda, that's not the existing law. Show us practice where the practice of international organizations has counted. And the answer to that, we said very clearly, we are stating the existing law. That is our belief as to what the existing methodology is. We're not trying to say what it should be in the future. We're not trying to address what it might have been 50 years ago when people would have insisted on 40 years of practice or whatever these rather rigid, very positivist approaches to the subject were. This isn't the first time that an effort has been made to set out how customary international law should be identified. You may recall that the International Law Association tried to do this in 2000 in the so-called London Statement of Principles, applicable to the formation of general customary international law with commentary. Very much a very similar exercise, but quite a different conclusion in some respects. We found it very useful, this previous work by a purely private organization, the International Law Association, but we differed from it in some respects. A particular one is that in the year 2000, leading up to it, we get some interference. The International Law Commission, the International Law Association had great difficulty with coming up with a conclusion or principle about General Assembly resolutions. That was very controversial in the 1970s and the 1980s. By the time we were working on it, it was much less controversial. I think there was general acceptance that General Assembly resolutions may include important evidence of the opinio juris of states. They might even reflect the practice of states, but one has to approach them with very considerable caution. We'll have noted that recently the International Law Commission, the International Court of Justice, gave a lot of weight to General Assembly resolutions in the Chagos advisory opinion, considering the question of the right of self-determination and the specific question, when did the right of self-determination become a rule of customary international law? Very interesting debate. I don't think that they took a different position from that which we find in the International Law Commission's conclusions. I may disagree with the way their conclusion, but the methodology, I think, is impeccable as always. So just to say how we went about the task, because it's quite interesting. There's very little or relatively little material that one can look at to determine what the methodology should be. We first tried to look at state practice, and there is very little state practice or statements by states as to what the methodology should be. Occasionally in court proceedings, they may say things. They said quite a lot in relation to the ICRC's study on customary international humanitarian law. There were certain criticisms of that from the United States, the United Kingdom and others, which gave an indication as to what they thought, how they thought rules of customary international law should be identified, but very little state practice. We then looked at decisions of courts. And of course, there was a lot. There's a lot of guidance in the various decisions and even in some of the separate opinions of the International Court of Justice and of certain other international or regional courts, but especially the International Court of Justice. And also there's some guidance from some national courts. There are some really interesting national court decisions, including historic ones, like those of the US Supreme Court in the 19th century, that give guidance. On the whole, I think that the Commission's work is based more on the work of the International Law Commission than on anything else. We also looked for guidance at academic writings, and there are some very interesting writings on the subject, particularly for me, because he was my teacher, Professor Clive Parry at Cambridge, his book on the sources of international law, and then much more recently, Hugh Thirlway's book on the sources of international law contain very interesting materials, but so do a lot of other writers, and particularly the various textbooks all have a section on this, and some of those are very useful and give very useful guidance. Interestingly enough, the very fact of the Commission taking up this subject led to states expressing views about it. So when we started in 2012, there was very little material from states, very few statements by states about how to identify customary international law. By the time we finished in 2018, we had a massive indications from states about what they thought. And I have to say there were some very useful and very thoughtful statements made in the Sixth Committee by countries from all regions of the world in the debates in 2015, 2016, and then again in 2018. So the very fact of taking up a topic leads to practice and information, if you like. You saw the same with the law of the sea in the 1930s. The fact that the League of Nations decided to study the law of the sea and have a codification conference, a failed one at that, even so, led to states submitting their views on the customary international law of the sea. So the very fact of taking up a topic actually creates or stimulates state practice, if you like. So I think that by the end of the project, we had a lot of information, a lot more information than we had at the start. I'll now just talk very briefly about some of the other more difficult issues within the text. Or firstly, the text overall of the conclusions, they start with a statement, a very clear statement of the two-element approach. And this may seem a statement of the obvious. I think it's rather good to state the obvious from time to time, because so much writing is trying to destroy the obvious or take it apart. So the very fact of stating the obvious is useful. One of the more interesting criticisms of the two-element approach from, for example, Professor Hagenmacher in Geneva, is that it's ahistorical, that in Article 38, 1b of the Statute of the International Court of Justice, which of course refers to international custom as evidence of a general practice accepted as law. At that time, although you have the reference to practice and you have the reference to accepted as law, they were thought of as a single exercise. They weren't divided into two elements. It was a general practice accepted as law. That may be so. And it was only the International Court of Justice in the Lotus case that then split the two and said, firstly, you have to look for practice, then you have to look for opinio juris or acceptance as law. And it's very interesting, that debate. He's right, I think. He may well be right. But the fact of the matter is that since the Lotus case, international lawyers generally, the International Court and other international courts have always, I think consistently, the practitioners among them anyway, said you have to have these two elements. So the endorsement of the two-element approach, I think, is an important, if pretty obvious, factor that comes out of the conclusions. They're then divided up. We have a section on what is a general practice. I've already mentioned the most interesting aspect there, which is that under certain conditions, general practice may include the practice of international organizations. Interestingly enough, in 1920, those who drafted the statute did not say state practice, even though some of the proposals were to say the practice of nations. They said practice. So it leaves open the possibility that this is also the practice of other international persons, and primarily of international organizations. We then said that practice must be general. That, of course, is essential, but impossible to quantify. And in the commentaries, we've given some of the key statements from the International Court of Justice, which try to specify what is meant by general practice. But one important point is we said that provided the practice is general, no particular duration is required. As I mentioned earlier, in the old days, states used to say, well, unless something has been there from time immemorial, or unless the practice has been around for 40 years, it can't have become a rule of law. That's obviously not the case. We had the rather rapid development of customary law on the continental shelf, the even more rapid development of customary international law on certain outer space matters, even leading Professor Bin Cheng to refer to instant customary international law, where we say there's no such thing as instant customary international law. That doesn't make sense, because custom has to have practice, has to have a certain duration. You have to have one or two or more examples. It can't be instant. But we did say no particular duration is required. And then the next part, part 4, deals with acceptance as law. Perhaps in a way, the most interesting part is part 5, which tries to just look at certain materials which are particularly significant when you're trying to identify customary international law. The first is treaties, where essentially we took the language of the court from the North Sea continental shelf case. The second, conclusion 12, are resolutions of international organizations, which is very cautious. but was not, somewhat to my surprise, controversial. The third specific material are decisions of courts and tribunals. There, a very interesting point arose, which was whether the decisions of national courts, which are obviously part of state practice, whether they can also be used as materials to assist in the determination of a rule of law. Can you use national courts as well as international courts? I think, to me, it's obvious that you can. A good decision, a well-reasoned decision by a national court can be as valuable as a decision of the International Court of Justice. You look at the Schooner Exchange in the United States or other important cases. But the French, for example, or certain French professors, I don't know if there's any listening, tended to say, no, it's only international decisions that's being referred to in Article 38(1)(d) of the International Court Statute. I don't believe that's the case. I don't know why, particularly in France, some people seem to think that. Maybe it's because French decisions never have any reasoning, and so they don't regard French decisions as relevant. But that's not true in many of our countries. Then the fourth conclusion of specific materials is teachings, where we thought long and hard. We tried to change the language of the International Court of Justice, which is rather old-fashioned, and we came back exactly to the language of the statute of the International Court of Justice. Teachings seem to us more general than writings, because it includes video teachings, things that are not written, but also it has a certain solemnity to it that writings doesn't have. We tried to come up with something better than the most highly qualified publicists, which is very odd language, particularly to an English-speaking person. I only realized in the course of this exercise that publicist didn't mean a sort of journalist or something like that, but it means a public lawyer, somebody who has studied public law, publiciste in French. Well, that's not quite right either, because we don't have public lawyers so much in England. We tend to just regard ourselves as lawyers. But anyway, teachings of the most highly qualified publicists, that's also a problem. Why the most highly qualified publicists? Well, I think that's not a good phrase. What seems to me to be relevant is whether what they write is good, not whether they're highly qualified, but maybe the two go together, but not always. It's really good writings or good teachings that are a useful subsidiary means. And then of the various nations is very important, as I mentioned earlier. You have to look at writings from as wide a range of countries as possible. Just to be very quick on two final matters that I find very interesting. Well, actually, I've mentioned one already, the conclusion on the persistent objector rule, where we repeated that rule, where a state has objected to a rule of customary international law while the rule is in the process of formation. That rule is not opposable to the state's concern if it maintains its objection. And then we really tried to limit that rule because it's very exceptional, but it does happen occasionally. And we said the objection must be clearly expressed. It must be made known to other states, and it must be maintained persistently. So you have to keep repeating it from time to time as occasion demands, or at least maintain it persistently. So, as I say, that proved popular with states. I think it's also useful what we've done because it limits it. It means you can't just say, well, we've never accepted this rule. You've got to show that you've expressed that very clearly, publicly made known to other states, and persistently, to be a persistent objector. And as you know, often people start off as persistent objectors, but very rapidly give in and come along to and become bound by the rule of customary international law. And then finally, there's a conclusion on what we call particular customary international law. This is sometimes referred to as regional customary international law, or local, or bilateral, or whatever. But we thought the word particular captured it better than these other things, because it can be regional, it can be sub-regional. There was a lot of talk about Latin American customary international law quite a few decades ago, but also in certain fields like diplomatic asylum. It's was argued in the asylum case that there was such a regional customary international law or sub-regional customary international law. So anyway, we accepted that there could be such a form of customary international law, as the International Court has said. It's fairly unusual, I would say. One interesting question, and this was a bit controversial in the Commission, is whether you can have particular customary international law that doesn't have a geographical limitation, that is among states from different geographical regions. And one possible example in the past would have been socialist customary international law, which may have been mainly in Eastern Europe and parts of Asia, but would have also included Cuba, perhaps. So not really regional. It's more an interest group. It's more a particular way of looking at the law. So we did say that a rule of particular customary international law, whether regional, local, or other, and the or other was meant to cover, for example, non-regional, non-geographic rules of customary international law. That was controversial because some members of the Commission, one or two, said, but give us some examples. There's no practice of this. You've shown nothing to establish that you can have other non-geographically based rules of customary international law. To which some of us said, no, but there might be, so let's put it in anyway. We don't have to show evidence for every single thing. It's obvious that there could be, which wasn't a very good argument. But anyway, we got away with it and it's there. And I don't think that's actually particularly controversial, though it was within the Commission. I've spent more time than I meant to. I think it would be good for me to stop now and listen to questions.
Oh, okay, Professor. Thank you very much for this very important lecture in the beginning of works. I'm so sorry to call you all the time, Professor. This is what I mean, a vicious way in the academy. I'm so sorry. Actually, it's extremely important for us to listen. A practitioner, mainly working in the International Law Commission, and I'm so sorry again.
No.
Sir Wood, and you are also a sir, and I'm calling you Mr., and I'm so
fine.
sorry.
That's not a problem. Call me Michael.
Okay,
Maria,
Michael. Okay, thank you. Well, it was a really important approach, in very, very sophisticated approach, and we need to listen you and make some reflections about this theme and how to work with this problem of how the International Law Commission can interfere in the behavior of the states in this international law, in the international relations ambience. I was with the problem here because we are in the domestic way working, and so I had this neighbor who started hitting the wall and my dog barking. So I had to use my headphones and I lost a little bit of my attention. I'm so sorry. I know that you saw it. Well, let's move on with the questions. We have some questions here, and I would like to ask you to answer for us. Okay. Can I begin with the questions, Professor?
Please.
Yes, okay.
Please.
So we began this morning. Oh, all right. Yes, I know you can.
Okay.
We began this morning with Sarah asking you the first beginning of the morning for us, the morning here, but the beginning of the afternoon for you. I think so. Sarah asked here, good morning, Sir Wood. I would like to know your thoughts on the possible impact that the U.S. Supreme Court judging on JAM versus IFC could have on a forming customary law of the International Organization Immunity. Thank you.
Well, I haven't studied the JAM case in detail, but from what I understand, the decision of the Supreme Court is really about US law, about the US law on the immunity of international organizations, and about the particular provisions that apply to the IFC. So I think that it probably doesn't have any influence on customary international law in this field. I have to say that the customary international law on the immunity of international organizations is a subject I'm very interested in, because I wrote a long article about it on the instructions of Professor Blocher from the University of Leiden, who said, we're having a conference, you must write about this subject. And I'd never thought about it, so I did a lot of work. And my conclusion was that international organizations do not enjoy immunity under customary international law. It's only by virtue of their treaties that they have immunity. Of course, there are many treaties, but then there are cases where states are not parties to those treaties. And I've tried to think, for example, if somebody were to sue the World Health Organization in a state where there's no treaty, would the World Health Organization have immunity under customary international law? It's just an example I pick out of nowhere. And it's not a real problem I've had to face, but I just thought it would be an interesting study. So that's a short answer to that question.
Okay. Thank you. All right. The next question is from Rodrigo Franco. Sir Wood, what is the whole customary law place on assuring the judicialability of the ILC drafts which were not transformed into conventions in the ICJ, for instance, the articles on state responsibility?
Well, that's an excellent question, Rodrigo, because
it's one of the points.
Something which I meant to say in the talk, but didn't, but forgot to have time to. The value of the output of the International Law Commission can be very great. Even when it's not referred to, the International Court often uses the language from the International Law Commission. But now more and more it refers to it in the case of state responsibility, for example, and the responsibility of international organizations. In the course of this exercise on identification of customary international law, the question arose, what should we say about our own product? We've talked about treaties, resolutions, judicial decisions, and writings, but what about our own product?
Mhm.
Surely that's very important, say people. And in my reports, I said, it's just a form of writing. It's a kind of collective writing, a bit like the work of the Institut de Droit International or the International Law Association. So we should mention it in the commentary under writings. And some members of the commission were rather shocked. They said, no, we're much more important than that. Look at us. We should have a whole conclusion about ourselves. And I said, no, we really don't want, that'll look very bad if we have a whole conclusion about ourselves. But it is an important matter, I agree. But where to put it? Where to put it? So in the end, if you look in part 5, which is the part dealing with the specific materials, treaties, etc., there's an introductory paragraph to that part. And in the introductory paragraph, we set out what we think of our own product. Okay. And I'll just read it because it's quite interesting, I think. We say, as has been recognized by the International Court and other courts, a determination by the Commission affirming the existence and content of a rule of customary international law may have particular value, as may a conclusion by it that no such rule exists. Then we said this flows from the Commission's unique mandate as a subsidiary organ of the General Assembly to promote progressive development and codification. The thoroughness of its procedures, including extensive surveys of state practice and opinio juris, and its close relationship with the General Assembly and states, including receiving oral and written comments from states as it proceeds with its work. And then comes the really important bit. We said the weight to be given to the Commission's determinations depends, however, on various factors, including the sources relied upon by the Commission, the stage reached in its work, and above all, upon states' reception of its output. So my short answer to Rodrigo would be that it can be important, but to know how important it is, you need to look at what states have said about it. It's no use just reading what the Commission did. You need to see what they said in the 6th Committee, what they've said in any resolution, what qualifications they've made. And for example, in the case of state responsibility, there were some rather clear qualifications by states saying that the provisions about jus cogens are not necessarily customary international law. And indeed, the Commission itself said that in its commentary. So it needs a very careful assessment. One shouldn't just automatically say, well, the Commission said this, therefore we can say it's the law. Thank you.
Okay. Thank you. Thank you. Very, very interesting. This is the one of the main important problem for us teachers of international law, the problem of the jus cogens and how to realize it in the reality of the international relations of the states and this environment.
Yes.
Very interesting approach. Okay, and now we have Vinicius. Vinicius is asking, Professor, not Professor, Sir, would how to avoid the international customary law reflects only international practices from the Western world? Do you think that the formation of this law is biased by a certain moral?
Right. Well, one other controversial matter in the Commission's work on this topic was what to say about specially affected states. If you remember, in the North Sea continental shelf case, it said that the practice has to be general, but it also has to include the practice of specially affected states. And that's often taken as a reference to the big states, maybe the permanent members of the Security Council. But it's not actually what it's saying. It's saying specially affected states. You have to see which states are affected. So the customary international law on passage through international straits would depend very much upon the practice of the states bordering the straits and the major shipping company states whose vessels are relying upon passage through the states. So it's not just the most important, the biggest states. So that's my answer in a general sense, but the question was more about Western states. I think there is a problem, which we're all very conscious of, that the practice of states tends to be published more by the Western states. The United States is very, very good at publishing its practice, volumes of it, and we all look at it and we all find it useful. That makes the United States very influential. Other countries, particularly perhaps the European ones, do that too, but it's also done by other countries, and they should be encouraged to do it. And it's a big job, it's a difficult job, but nowadays practice is available from all around the world. And this document I mentioned at the beginning that the Secretariat have published, Ways and Means for Identifying Customary International Law, deals with the practice of 190 states or international organizations, and it lists the websites where you can go to. So I don't think it's the case that customary international law is dominated by the practice of Western countries. I mean, one would have to go through different areas, but if you look at the law of the sea, the developing countries, particularly the Latin American countries, if I may say so, had a huge influence on the law of the sea through their practice, through their activity at the Law of the Sea conference, but especially through their practice. And the modern law of the sea is largely written by developing countries and by the Latin countries, I would say, or large parts of it are. So I think it's a bit of a caricature to take the view that this is just a Western thing. I mean, that's what the Soviet Union lawyers said immediately after the October Revolution. They said, we don't believe in customary international law. This was just written down by the capitalist states. But they very rapidly came round to saying, actually, we agree with it and we find it quite useful and we can use it, which is exactly the same position that the newly independent states took in the 1960s and 70s. They said, we can't be bothered with customary international law. Why should we accept it? We had nothing to do with it. But they very rapidly came around to accepting it, and they can influence its future development. Thank you.
Yeah. Okay. Thank you. Maybe this is a historical view of the international law that in the past it was centered in the Europe law. Maybe we have to change this situation. Oh, now we have Flavia. Flavia is asking, Sir Wood, I would like to know your opinion about the importance of customary international law in the implementation of humanitarian law and its current challenges faced by the international society.
Well, I think it's very important indeed, because as you know, most of the treaty law in the case of international humanitarian law in the sense of the law of armed conflict relates to international armed conflict. We're faced these days with so many non-international armed conflicts. The application of customary international law to what's going on in Syria now is immensely important, determining the law relating to detainees and the like. It's hugely important. I think the ICRC did a very good job, and they're continuing to do a very good job by keeping it up to date with their study of customary international humanitarian law. So if it's that sort of humanitarian law, I think the answer can only be that it's very, very important. There are particular problems, but they're greatly helped by the very good work that the ICRC is doing. And that really is, to go back to the previous question, worldwide. They're not just looking at the practice of Western states by any means. If the question is more about international human rights law, then I think that's more difficult. There are so many treaties. States are bound by these treaties. The mechanisms relate to the treaties. But undoubtedly there is customary international human rights law. But what its exact content is difficult to say sometimes, given that the treaties vary among themselves, given that the judgments of the various and decisions of the various international bodies vary from region to region, as well as more generally. So I think there is a problem with international human rights law. It undoubtedly is important, customary international human rights law in my view, but it's not as clearly or as well developed as customary international humanitarian law. And then of course you get the intersection of the two, which is where I give up.
Yes. Okay. All right. So we have three more questions, and then we have to finish. Unfortunately, our lecture with Sir Wood. Now we have Fernando. Fernando is asking here, Sir Wood, how can the general practice of certain norms, such as the prohibition of torture, be ascertained given the often lack of consistent practice in that regard?
Right. Well, that's a question that's often asked, and rightly so. I think there one can assess the customary law nature of it by looking at all the other practice. There are cases, unfortunately, where torture is practiced. There are very many cases where states condemn that. Even the states that practice it condemn it. So I think that it's easy enough to construct a rule of customary international law based upon the very widespread acceptance of the UN Convention on Torture and other treaties. One can always also bear in mind the very helpful comment by the International Court of Justice in, I think, the Nicaragua case, saying that the fact that rules are broken doesn't undermine their status as rules, doesn't undermine the general practice. And they were talking there about the use of force by states, but the same can apply in the human rights field. It is one of the problems with customary international law of human rights, but I don't personally think it's insurmountable.
Okay. Thank you. Okay. Let's move on. Can we move on? Okay.
Yep.
Yes. Okay. Now we have Barbara asking, good morning, Sir Wood. I'd like to know to what extent the refusal of a state to follow a recognized custom should be regarded a breach of international law or a step on the evolution and change of such custom.
Yes. Very good question. Well, it could be both. You have to break international law to change it. Yes. I mean, obviously, this is a really difficult question. I'd have to give a whole lecture and I'd have to think about it first. In the case, this exercise of the Commission was very limited. It's the identification of rules of customary international law. We did not seek to discuss how rules of customary international law evolve, how they develop, which is a much more sociological thing. The original title of the topic which I came up with, was indeed formation and evidence of customary international law. And the French member of the commission said, you can't possibly deal with that. We should talk about the identification or the determination of rules of customary international law, because if we get into the whole question of how they're formed, we'll be here forever. You know, that's really, really difficult. Looking at all the material sources, I think you'd call them, of rules of law would be very difficult. It's enough to focus on the rules of recognition, if you like. But you know, obviously there are very obvious examples. If you take the 3-mile territorial sea, let's assume that there was a rule of customary international law that you couldn't have a territorial sea of more than 3 or 4 miles. Well, many states broke that. Eventually, they settled on 12 miles. But were they breaking it in the meantime? Actually, it's really as much a matter of opposability between pairs of states, that particular rule, and you get the United States saying we won't recognize 12-mile limit. We'll keep sailing up to 3 miles. So as between a state with 3 miles and a state with 12 miles, probably the 3 miles was the law for a long time. But as between 2 states with 12 miles, obviously they couldn't object to the 12-mile system. So international law, at least in the law of the sea, becomes very much a bilateral matter. You may say that undermines the whole notion of customary international law. It certainly is a difficult question, and perhaps a good place to end, unless there's another question.
Okay, all right. Yes.
The problem with this format is that the people who ask the question don't get to come back and say, you haven't answered my question.
Yes, yes, but she adds something here. She said, I'm thinking about Italy's position after the jurisdictional immunities case and the persistent objector situation. Thank you.
Right. Well,
now she was more specific.
Yeah, well, on that, Italy's position was outrageous. Of course, the position of its courts, but at least they said we're only applying constitutional law. We're not questioning the decision of the International Court of Justice.
Okay.
And we're just not obeying it because our constitutional law requires us to do what we do. And the Italian government, if you remember, although it argued the case, it actually disagreed with its own argument. It took the view that the law, that Germany had immunity. So it's a really interesting case. There are so many of these interesting cases. And it's not only Italy that has had problems of this nature. Thank you.
Okay, thank you. And now the last question we have here for this morning, Lucas is asking, and Sir Wood, I would like to ask what's the function of General Assembly resolutions in the formation of customary international law, and whether all resolutions should have the same weight. And he also adds, and if they have different weight, what is that provides this difference?
Yes, well, that's quite a big question. I could answer very simply by saying you should read conclusion 12 of the International Law Commission, and particularly its commentaries, because there we make it very clear that it's only in very specific circumstances that provisions of a resolution, not necessarily the resolution as a whole, might be significant to determine a rule of customary international law. I mean, we all know that most resolutions of the General Assembly are voted through on political grounds. They're not necessarily the views of the state reflecting its opinio juris. Sometimes they may be, for example, the Friendly Relations Declaration of 1970, which was negotiated over 6 years and was adopted expressly as a statement of rules of principles of customary international law in the very important fields it covers. But often resolutions are adopted by a vote.
Yes.
If there are significant votes against, then it's very unlikely that they could reflect customary international law. When they're adopted by consensus, you have to see what kind of a consensus it was. Were there lots of statements saying we don't really like this? Were they even purporting to be a statement of customary international law? One example I find quite amusing, but I'll get into a lot of trouble for saying this. If you look at the resolution on principles, the rights of indigenous peoples declaration from 2007, in the preamble, it actually says, wishing to adopt the following declaration as an aspiration. So it's saying on the face of it that it's not laying down the law. This is an aspiration.
Okay.
Well, some of it may be, and quite a lot of it probably has since then, though there were some votes against. 4 states, the 4 with the most indigenous people, voted against it. They may have come into line more recently and have accepted it, but it's very subtle. And my short answer to the question is no. You have to look at each individual provision of each resolution.
And he also adds something to this question. He would like to know whether you see there can be an impact of intertemporal law in the formation of customary international law based on state practice, contrary to an international treaty.
That's quite a difficult question.
Yes, it is.
Put it politely. I mean, obviously, the intertemporal law is the intertemporal law. You have to weigh practice in the context of the time when it took place. So all the practice from the 19th century for colonization, for invasions, for this, that, and the other, clearly doesn't carry weight for now, if that's the sort of intertemporal law. I don't really see a particular issue. Obviously, practice and opinio juris have to be weighed up in the context of the time when they take place and their relevance. Well, the other thing is obviously a treaty may codify or reflect or become, its rules may become customary international law, like much of the law of the Sea Convention, but that doesn't stop new customary international law developing that may even be contrary to the treaty. So one has to look very carefully at post-treaty customary international law.
Okay, thank you very much. So, Sir Wood, we finished this fundamental lecture for international law. Thank you deeply once again for your participation, and we hope to see you in person here in another occasion here in Brazil.
I'd very much like
enjoy
that.
Our sun.
Yes, thank you very much, Maria, and I certainly hope to come to Belo Horizonte again.
Yes, please.
I have been once.
Yes, it would be great for us.
On another occasion. Thank you very much indeed.
Another occasion.
And
thank
goodbye
you very much.
Thank you for your patience.
Thank you. Bye-bye. Thank you.
Bye.
It was not a patience. It was a pleasure.
Bye-bye.
Bye-bye.